The year 2026 is shaping up to be one of the most challenging periods green card holders have faced in decades, and many people are dangerously unprepared for what is coming. If you believe that having a green card automatically protects you from scrutiny, detention, or removal, that assumption could put your future at serious risk. Immigration enforcement priorities are changing, data sharing systems are becoming more sophisticated, and past issues that once seemed irrelevant are now resurfacing with real consequences. For green card holders, especially those with any history involving the criminal justice system, traffic violations, or extended travel outside the United States, the margin for error is shrinking fast. One of the most critical realities of 2026 is the renewed focus on old convictions. Many green card holders assume that something that happened 10, 15, or even 20 years ago no longer matters. From an immigration perspective, that belief is incorrect. Immigration law does not follow the same logic as criminal law when it comes to time. A conviction does not simply disappear because years have passed or because a person has lived a clean life since then. Old arrests, dismissed charges, and convictions that were never an issue before are now being reviewed again, particularly during international travel or when applying for naturalization. Immigration authorities are increasingly revisiting historical records and using them to assess admissibility, removability, and moral character. This shift is especially visible at airports and ports of entry. Green card holders who travel abroad are being questioned more aggressively upon return, sometimes detained for hours or even days, based solely on incidents that occurred decades earlier. In many cases, these individuals had no problems traveling in the past, which creates a false sense of security. The reality is that systems have changed, priorities have changed, and enforcement has intensified. What passed unnoticed before may now trigger secondary inspection, detention, or referral to immigration court. Travel is no longer routine for green card holders with unresolved or poorly documented past issues. Another major concern moving into 2026 is the treatment of misdemeanors and driving-related offenses. While a single minor offense may not automatically result in removal proceedings, patterns matter. Multiple offenses, even if spread over many years, can be viewed as evidence of poor judgment or lack of good moral character. This includes multiple speeding tickets, repeated driving without insurance, reckless driving citations, and especially DUIs. Alcohol-related offenses receive heightened attention, and more than one DUI can place a green card holder in a high-risk category, particularly when combined with other factors such as travel, long absences, or prior arrests. Drug-related offenses and domestic violence issues are treated even more seriously. In some situations, even a single conviction can create immigration consequences that are far more severe than people expect. What is especially dangerous is assuming that a case was minor or handled in criminal court, and therefore irrelevant to immigration. Immigration law operates independently, and its definitions and consequences are often much broader. As enforcement increases in 2026, these distinctions matter more than ever. International travel presents one of the greatest risks for green card holders right now. When a permanent resident leaves the United States, they are no longer evaluated solely as someone who already belongs here. Instead, they are inspected as someone seeking admission. That legal distinction is crucial. Issues such as long absences, unclear residence ties, expired or questionable re-entry permits, and past criminal history can all be used to challenge a person's right to return. Even individuals who believe they followed all the rules are being asked to justify where they live, where they work, and where they truly intend to reside. Extended time outside the United States has become a particular red flag. Absences of more than 6 months raise questions, and absences approaching or exceeding 1 year significantly increase scrutiny. Officers now have better tracking tools to review travel patterns, and they are using that data actively. Some green card holders are pressured at the airport to sign documents abandoning their status, often during stressful interrogation. Many people do not realize that surrendering a green card is voluntary and that only an immigration judge has the authority to formally take it away. Fear and confusion, however, lead some individuals to make irreversible decisions in the moment. Re-entry permits, while helpful, are not absolute protection. Holding one does not guarantee admission. Officers may still question the purpose of travel, the length of absence, and whether the individual truly maintained ties to the United States. Supporting documentation has become increasingly important, including evidence of employment, family connections, property, tax filings, and intent to return. The burden is effectively shifting toward the green card holder to prove continued eligibility rather than the government having to prove otherwise. Policy enforcement trends that began earlier are expected to continue and expand through 2026. Immigration officers now have broader discretion to detain green card holders at ports of entry if concerns arise. Detention does not mean loss of status, but it can involve days or weeks in custody while a case is reviewed or bond is requested. This reality alone should prompt green card holders to take preparation seriously. Detention is disruptive, expensive, emotionally draining, and often avoidable with proper planning and awareness. It is also important to understand the difference between being inside the United States and attempting to re-enter it. A green card holder with past issues may not be immediately removable while inside the country, but once they leave, they can be deemed inadmissible upon return. That distinction catches many people off guard. Travel transforms legal exposure, and 2026 is making that exposure far more visible and consequential. Against this backdrop, citizenship has become one of the most important forms of protection available. For those who are eligible, naturalization provides security that permanent residence does not. Citizens are not subject to the same admissibility standards, are far less vulnerable during travel, and are insulated from many of the enforcement actions currently affecting green card holders. At the same time, the citizenship process itself is becoming more demanding. Scrutiny of moral character has intensified, and even traffic-related histories are receiving closer review. Waiting carries risk. As standards tighten and enforcement grows more aggressive, delaying an application can mean facing new obstacles that did not exist before. Eligibility today does not guarantee eligibility tomorrow. For many green card holders, applying for citizenship as soon as legally possible is not just a milestone, but a strategic necessity. The overarching message for 2026 is awareness and preparation. Green card holders must understand their own history, including arrests, convictions, travel patterns, and documentation. Assuming that the past no longer matters is no longer safe. Immigration enforcement is evolving, and those changes are arriving quickly. With the right knowledge and proactive steps, many risks can be managed or avoided. Ignoring them, however, could place lawful permanent residents in situations they never expected to face. Staying informed, cautious, and proactive is no longer optional. The landscape is changing, and 2026 will reward preparation while punishing complacency.